Who's held responsible when an entire river is contaminated by an oil spill? Today, we explain what Ecuadorian law says and why it's not enough to just clean what's visible. Ecuador is one of the most biodiverse countries in the world and also one of the most oil dependent. Every year, hundreds of communities live between promises of development and the reality of contamination. Between 2020 and 2024 alone, over 30 spills were publicly reported, affecting rivers, soils, and human lives. But beyond the media outrage, what happens from a legal standpoint? What does Ecuadorian law say when a company, public or private, pollutes entire ecosystems? Who must repair the damage? How and according to what standards? Today at In Solidum Lawyers, we analyze Ecuador's current legal framework for oil spills with a focus on civil, environmental, criminal, and constitutional liability. We'll also review the rights of affected communities and the mechanisms existing or lacking to ensure full reparation. In Ecuador, oil spills are regulated by a cross-cutting legal framework. Constitution grants rights to nature as a legal subject. Environmental management law and its regulations establish obligations to prevent and repair environmental damage. Organic Environmental Code applies a strict liability to the polluter. Fault doesn't matter. If you pollute, you pay. Comprehensive Criminal Code criminalizes environmental pollution with penalties of up to 7 years. Additionally, protection actions, environmental precautionary measures, and civil lawsuits for direct damages, lost profits, and moral harm may be activated. Both private and state-owned companies such as PetroAmazonas or PetroEcuador are legally required to implement prevention and contingency systems, immediately report any environmental incidents, take corrective action without delay, assume remediation costs in full, comply with environmental audits, and respond to administrative proceedings led by the Ministry of Environmental or Environmental Prosecutor's Office. Meanwhile, the state holds an inalienable duty to monitor, control, and ensure full environmental restoration even when the polluter is a public entity. Although Ecuador's legal framework is robust on paper, in practice several issues persist. Delays in the legal proceeding of cases, limited application of the precautionary principle, difficulties in ensuring full reparation for indigenous or rural communities, lack of an independent national environmental monitoring system. Many court rulings focus only on superficial cleanup without properly assessing long-term ecological damage or applying tools like participatory environmental expert analysis. In regions like the Amazon, the tension between national economic interests and collective and environmental rights remains a persistent legal battleground. Oil spills don't just affect water or soil, they impact lives, cultures, and the future of entire generations. Ecuador's legal system recognizes this, but its effectiveness depends on technical, decisive, and uncompromising enforcement. At In Solidum Lawyers, we believe in a development model based on responsibility, where the law serves as a shield, not a formality. If this analysis helped clarify the issue, subscribe to our channel, share this video with your network, and tell us in the comments, do you think the principles of full environmental reparation are being fulfilled in recent oil spill cases? Or are we still far from true environmental justice? We'll see you in the next episode, where we analyze the present with a vision for the future.